Zambia is a former British colony which gained its independence on 24th October 1964. It is a constitutional democracy whose attainment of independence opened a new chapter for the Zambian people to govern themselves and to fully determine the political, social, and economic order.
Regarding legislative authority, which is vested in Parliament, the Constitution of Zambia, Chapter 1 of the Laws of Zambia, categorically stipulates in Article 61 that the legislative authority of the Republic derives from the people of Zambia and shall be exercised in a manner that protects this Constitution and promotes the democratic governance of the Republic. Further, the Constitution of Zambia provides for the laws applicable to Zambia. It stipulates in Article 7 that the laws of Zambia consist of this Constitution, laws enacted by Parliament, statutory instruments, Zambian customary law which is consistent with this Constitution, and the laws and statutes which apply or extend to Zambia as prescribed.
In exercising the sovereign and legislative authority, Zambia enacted the British Acts Extension Act, Chapter 10 of the Laws of Zambia. This Act of Parliament extends and sets forth in the schedule the British Acts which are deemed to be of full force and effect within Zambia. The following are the British Acts extended to Zambia under the British Acts Extension Act: the Conveyancing Act, 1911, the Forgery Act, 1913, the Industrial and Provident Societies Amendment Act, 1913, the Larceny Act, 1916, the Bills of Exchange Time of Noting Act, 1917, the Married Women Maintenance Act, 1920, the Gaming Act, 1922, the Industrial and Provident Societies Amendment Act, 1928, the Limitation Act, 1939, and the Law Reform Enforcement of Contracts Act, 1954.
In 2017, the Minister of Justice instructed the Zambia Law Development Commission to conduct a review of the British Acts Extension Act. The instruction was motivated by the following. Extending British acts to Zambia reflected a colonial legacy, and after 53 years of independence, it was time for Zambia to enact its own indigenous legislation. The United Kingdom has, to a large extent, repealed or substantially amended the acts that extend to Zambia, while Zambia continues to apply archaic legislation.
The rationale for the review of the British Acts extended to Zambia was to assess their relevance vis-a-vis whether they are in use, whether they match up to contemporary developments, and whether they support the country's development agenda. It was envisaged that if some British acts extended to Zambia or their specific provisions were found to be relevant, they should be adapted in the development of indigenous legislation.
The general objective of the review process was to review the relevance of the laws extended to Zambia by virtue of the British Acts Extension Act, Chapter 10 of the Laws of Zambia, in order to develop a comprehensive indigenous legal framework that is reflective of the social-political values of the Zambian people. The specific objectives were to conduct a legislative audit of British statutes applicable to Zambia by virtue of Cap 10, so as to determine their relevance and adequacy. Identify and enhance domestic legislation by adapting relevant provisions from the British Acts extended to Zambia by virtue of Cap 10. Consider international and regional instruments relevant to the British Acts extended to Zambia and make recommendations for their ratification or domestication, and make specific findings and recommendations to inform the development of indigenous laws and the repeal of Cap 10. The Commission employed a qualitative research approach to answer the research questions. The review process employed an exploratory research design which was concerned with understanding broad-ranging, purposive, systematic, prearranged undertaking designed to maximize the discovery of generalizations leading to description and understanding. As part of the review process, an in-depth review of available primary and secondary data sources was conducted through a desk review. The target population for the review process, who were purposefully selected, comprised members from the Law Association of Zambia and the judiciary in Lusaka and the Copper Belt. After the compilation of the report, the Commission availed the report to State Council for advice on the feasibility of the recommendations made. Following the review of the British Acts extended to Zambia, the Commission made the following findings and recommendations. Conveyancing and Law of Property Act 1881 as amended by Conveyancing Act of 1911. The provisions of the Conveyancing Act are still relevant to Zambia. They are instructive on issues relating to, among others, power of sale, mortgages, and instruments used in conveyancing. Despite some Zambian acts, such as the Land and Deeds Registry Act, Lands Act, Lands Perpetual Succession Act, Trust Restrictions Act, and Wills and Trusts Administration Act, having certain similar provisions with the Conveyancing Act, the provisions are not comprehensive. Provisions from the Conveyancing Act can be adopted to enhance Zambian legislation. Some provisions of the Act are incompatible with the Zambian system of land tenure. These include provisions that make reference to land held under fee, tail, or freehold. Such provisions should be discarded when redrafting relevant provision. The Act provides for, among others, powers relating to estate or interest of mortgagees, regulation of power of sale, powers of remuneration, and duties of receiver and sale of mortgaged property in action of foreclosure. However, the Land and Deeds Registry Act has insufficient provisions on the aforementioned powers and therefore the need to incorporate them in the Act. The Act provides for conveyancing of land relating to deceased persons. The same is covered under the Interstate Succession Act, Chapter 59 of the Laws of Zambia, and the Wills and Administration of State Estates Act, Chapter 60 of the Laws of Zambia, which equally make provisions on such matters. The Act provides for powers of attorney, while local legislation was found to have insufficient provisions on power of attorney. The Act regulates various issues concerning the operations of trustees and executors, beginning with the appointment of new trustees and vesting of trust. However, it was found that the Trust Restriction Act, Chapter 63 of the Laws of Zambia, has insufficient provisions to regulate trusts. Therefore, the Conveyancing Act can be used to strengthen the Trust Restriction Act.
Industrial Provident Societies Amendment Act 1913 and 1928. The Act provides for the registration and regulation of industrial and provident societies. It was found that the Industrial Provident Societies Amendment Act 1913 and 1928 may not be relevant, as they are not currently referred to for the registration of societies, and no evidence was found to support the assertion that they are indeed in existence in Zambia. There are sufficient provisions that provide for the registration and regulation of societies and cooperatives in Zambia under the Societies Act and the Cooperative Societies Act. Therefore, these acts can be done away with as they have no relevance to the Zambian legal system. Despite not having evidence of industrial provident societies existing in Zambia, there is a need to insert a transitional provision in either the Cooperative Societies Act or the Societies Act to provide for the transition of industrial and provident societies as if registered under those acts in case there are some industrial and provident societies in existence.
Law Reform Enforcement of Contracts Act 1954. The Act was enacted to amend Section 4 of the Statute of Frauds 1677 and to repeal Section 4 of Sales of Goods Act 1893. It was noted that the Act has no relevance to Zambia. The Act has no significant relevance to Zambia, hence the need to discard it. Stakeholders further submitted that with regard to Cap 10, the Act is relevant. However, Section 1, referring to the Statute of Frauds 1677, should be considered when reviewing the English Law Extent of Application Act, Chapter 11 of the Laws of Zambia. Limitation Act 1939. The Act is relevant to the Zambian legal system. This is evident in court judgments where courts have dismissed actions for being statute barred on the basis of the provisions of the Limitation Act 1939. The Act is relevant and there is need to enact a Zambian Limitation Act whose provisions would be adapted from the Limitations Act 1939. Some provisions in the Act are incompatible with the Zambian system of land tenure. The Act provides for limitation periods in respect of advowsons, which relate to the special relationship between the Crown and the Anglican Church in England. In the development of the Zambian Limitation Act, there is need to do away with any reference to the Church. The Act is drafted in a manner that makes it difficult to comprehend. The Zambian Limitation Act should be drafted in an easy-to-understand language, and that its provisions should be concise.
Married Women Maintenance Act 1920. This act provides for the maintenance of children of a marriage by a husband. The maintenance of children of marriage is adequately provided for under the Matrimonial Causes Act and the Children's Code Act. Consequently, Zambia should discard the Married Women Maintenance Act, which was repealed in England and replaced with the Child Maintenance and Other Payments Act 2008. Larceny Act 1960. This act provides for the offense of theft in the many forms that it may occur. The act is not relevant as it is not referred to at all in the prosecution of the offense of theft. The offenses in the act are adequately provided for in Zambian legislation, such as the Penal Code Act, Chapter 87 of the Laws of Zambia, Criminal Procedure Code Act, Chapter 88 of the Laws of Zambia, the Electricity Act No. 11 of 2019, and Anti-Corruption Act No. 3 of 2012. Therefore, it should be discarded. Further, the Act has some provisions that are archaic and inconsistent with the Zambian legal system. For example, it provides for corporal punishment, which has been outlawed in Zambia. Therefore, the application of the Larceny Act to Zambia may be done away with. Forgery Act 1913. The Forgery Act provides for the offense of forgery in all the forms that it may occur. The Act is not relevant as it is not referred to at all in the prosecution of forgery and related offenses. The offense of forgery and related offenses are provided for in Parts 35 and 34 of the Penal Code Act, Chapter 87 of the Laws of Zambia, and various sections in the Criminal Procedure Code Act, Chapter 88 of the Laws of Zambia. However, the Forgery Act contains provisions that may be adapted to the Penal Code Act. For instance, it provides a more comprehensive definition of forgery than that which is provided for in the Penal Code Act. As the Penal Code and the Criminal Procedure Code Act are being amended, the definition and other comprehensive provisions in the Forgery Act should be adapted. The Commission has compiled its stakeholder submissions, specific findings, and has made recommendations regarding the British Act Extension Act, Chapter 10 of the Laws of Zambia. This is in line with its statutory mandate established under the Zambia Law Development Commission Act, Chapter 32 of the Laws of Zambia. The Commission wishes to thank the Ministry of Justice for entrusting it with the responsibility to undertake the review of the British Acts Extension Act, Chapter 10 of the Laws of Zambia. Thank you for your kind attention.